Computers Against War, and we've been organizing sort of vigil performances outside of the Metropolitan Correctional Center on Monday nights. It's one of a few local initiatives in support of Fahad and his case, the others being Free Fahad and Educators for Civil Liberties. I will be providing you with websites and more information on all those initiatives towards the end of the evening. The panel will feature Professor Jeanne Theoharis from Brooklyn College, who was one of Fahad's professors when he was a student there, Faisal Hashmi, Fahad's brother, as well as Shayana Kadidal from the Center for Constitutional Rights.
I mean, I sort of come to this case in two ways. I come to this case in a very personal way because Fahad was my student in 2002. He took, as I mentioned in the film, a senior seminar with me on post-civil rights racial politics, a seminar where students read a research paper. And so he did a 20-page research paper at the end of the class, and that paper focused, and again, this is 2002, on the abridgment of civil liberties in the wake of 9/11 that Muslim groups in the United States were facing. So I come to this case, right, as a professor and as a teacher in a very personal way. But I thought I would spend tonight talking a little bit about, I also come to this case as a scholar, and a scholar of racial politics in the 20th century and a scholar of African American history in the 20th century. And so what I wanted to kind of frame tonight, just for a few minutes, was the kind of question I think we haven't had enough discussion about in our sort of public conversation recently, and that is the use of the law, right? The use of the law to abridge civil rights. Because I think a lot of the conversation around Guantanamo focused on, look, we've taken these people outside the reach of the law. And many people have spoken, and lawyers and scholars have spoken very thoughtfully about what Guantanamo symbolized in terms of creating this place that was this sort of limbo place outside of the reach of the law. And obviously the Supreme Court has had some to say about how it's not fully out of the reach of the law. But I think a lot of our public conversation has turned on those spaces that are extra-legal or are these quasi-legal spaces. And I think we have not had enough of a public conversation about the way the law and the courts in the United States have been a site for the abrogation of rights and liberties in the wake of 9/11. And I think Fahad's case in particular, and I'm just going to speak about his case tonight, but I think it is actually unfortunately indicative of a kind of broader pattern, speaks to the way that the law actually allows for this. And in many ways, I think we need to be thinking about what's happening in the federal courts and what's happening to people like Fahad as a kind of modern-day Korematsu. And I think sometimes when I say this, people are like, no, Jeanne, maybe what you mean is special registration. Special registration is like internment, but not this. And I think what the fixation, clearly we have not seen the wholesale roundup of Muslims in this country, right? And so then people are like, no, we're not having internment. But I think the much more, troubling thing about Japanese-American internment during World War II, and I think the parallel and what we need to be thinking about now is the ways that the law allowed for that to happen, right? The ways that the law enabled the federal government to abridge the civil rights of a group of people, right, under the sort of guise, right, or under the reasoning of national security. And so I actually wanted to read a short bit of the Supreme Court's decision in Korematsu, except that I'm going to substitute a bit. So again, this is taken from the Supreme Court's majority opinion in Korematsu. All citizens alike, both in and out of uniform, feel the impact of war in greater or lesser measure. Citizenship has its responsibilities as well as its privileges, and in time of war, the burden is always heavier. But when under conditions of modern warfare, our shores are threatened by hostile forces, the power to protect must be commensurate with the threatened danger. Our task would be simple, our duty clear, were this a case involving the imprisonment of a loyal citizen in a concentration camp because of racial prejudice. Regardless of the true nature of the assembly and relocation centers, and we deem it unjustifiable to call them concentration camps with all the ugly connotation that term implies, we are dealing specifically with nothing but an exclusion order. To cast this case in terms of outlines of racial prejudice without reference to the real military dangers which were presented merely confuses the issue. Hashmi was not excluded because of hostility to him or his race or his religion. He was excluded because we are at war with Al-Qaeda. And obviously I have substituted Korematsu and the Japanese Empire for Hashmi and Al-Qaeda. But I think, and I don't have time, but I would urge you to go back and read the Supreme Court's decision in Korematsu and the Supreme Court's decision the year before in Hirabayashi, and they sound eerily familiar in terms of the kind of language we have returned to today, that there are times when we need to sort of scale back rights, right? There are times that we need, when we are at war, that different rules apply. And I think we can see this working in Hashmi's case, I think, in three distinct ways. And those ways are the conditions under which he's being confined, the ways that his due process rights have been abridged, and the way his First Amendment rights have been compromised. And by compromising his, I think it's about, again, sending a message. And again, all of these are being done through the law. So as the film briefly mentioned, Fahad was extradited to the United States, was apprehended in Britain in 2006, and was extradited in 2007. He was the first U.S. citizen to be extradited under these new laws, which relaxed the standard of extradition, and has been held since then in Metropolitan Correctional Center, which is in Lower Manhattan, about a mile from here, for 2.5 years in severe solitary confinement under what are called special administrative measures. And special administrative measures basically almost completely restrict the communication that a detainee would have with the outside world. So Fahad, with the exception of very limited letters and visits with his parents and access to his lawyer, is completely cut off from calls, visits, interactions with other prisoners, interaction with the outside world. He is monitored 24 hours a day. He is allowed 1 hour of exercise outside his cell, but he does not get that with... MCC has a facility on the roof. He does not get to use that. He is just moved to another, basically, room or cage where he gets exercise, so no fresh air. But all this is legal, and it's legal under something called special administrative measures, which was actually started not under George Bush, but under Bill Clinton. And was expanded in the wake of 9/11, and the rules very much loosened in terms of who could be put under SAMs and for how long. So the period under which you could be put under SAMs was increased. The standard for renewal was dramatically relaxed. So again, but this is all through the law. The second thing I would call our attention to is, again, the sort of due process issues, and particularly the use of secret evidence, right? And again, in our conversations about Guantanamo, there's been a lot of public outcry around the use of secret evidence, but in fact, even here in the federal courts, this has become much more common, and it is through something called the Classified Information Procedures Act that was actually started in 1981 for very different reasons, actually to prevent U.S. intelligence officers that the U.S. was seeking to to prosecute, right? It was very hard to prosecute our own intelligence officers because they would basically threaten to give away state secrets, right? They would gray mail the U.S. government. And so basically in 1981, they passed SEPA, which basically allows for certain kinds of evidence for certain portions of evidence or of the case to be classified and therefore illegal to speak in public. Right, so this is 1981. Fast forward, right, now we're in the post 9/11 moment, and this is dramatically increased. So what that means in Hashmi's case is, in Fahad's case, is that much of the evidence in his own case he has not been able to review. His lawyers have gone through what amounts to a kind of CIA level process of clearance, but he doesn't get to review much of that evidence. So clearly it very much affects his ability to participate in his own defense, obviously coupled with the SAMs, right? His ability to help his own defense, participate in his own defense, is very much kind of curtailed. The third issue that I think we need to be very concerned about, and I think, as the film mentioned, he is being charged under 4 counts of material support to terrorism, material support to Al-Qaeda, and many other people have written and spoken, obviously much more articulately than I will tonight, about the way that material support criminalizes association, right? That it's basically an end run around many of the cases of the 1960s that allowed for association with bad guys or dangerous people. The people the United States termed dangerous in the court by the late 60s said you were allowed to. So what material support does is it does an end run around that association by sort of claiming that there's actual materials, right? But materials, if you follow many of these cases, can range from linking your website to somebody's website to having, as in Fahad's case, letting a friend stay in your apartment and use your cell phone, right? So material support is become a kind of catch place for in many ways the United States criminalized association. And then I think the final thing I wanted to talk about is Fahad was a very political student when I knew him at Brooklyn College, and I think remained a very political student as he went to London to get his master's. And the U.S. government is prepared to use those politics, right, and is going to introduce tapes of those politics into court next month when the case goes to court. And the judge has allowed them a wide latitude to do so, right? And so his political activities, his constitutionally protected political activities, will become part of his trial and part of how they will seek to show intent. And of course they say, no, he's constitutionally allowed to say these things, but we're just going to use them anyways to show frame of mind, to show who he was, to show why, again, this acquaintance came to him to stay at his apartment. So I wanted to stop there, and we can obviously talk about this in more length, or where, we can take the conversation in a number of different directions, but I just wanted to lay out those kind of 3 big issues for us to kind of talk about afterwards.
So I guess it's my turn to talk. My name is Faisal Hashmi. I'm Fahad's older brother. I'm a year older than him. And when I was asked to speak about this, I said, how do I speak about this issue? My brother, he's my only brother. We're just 2 siblings. We came to this country in 1983 when I was 4 and he was about 3 years old. So we've been in this country, 26 years, growing up in Flushing. So how do I speak about this? And what came to my mind is you have to properly place what's happening to Fahad in context. And context is everything when you discuss his particular case. And I want to talk about a few details about the case. But I think this case, the actual accusations against him, have absolutely nothing to do with ponchos and socks. The full force of the U.S. government, federal prosecutors spending their time, I don't know how many FBI agents and Joint Terrorism Task Force people spending time and money over years prosecuting my brother or doing an investigation on my brother. All this money, which at minimum is $1 million from what I can guess. It has absolutely nothing to do with that a person stayed with my brother, and in this person's luggage were ponchos and socks, which this person went and delivered to Al-Qaeda, like the insurgency in Afghanistan is looking for ponchos and socks to come from London. That's the actual charges. Not that my brother did anything, that this person who subsequently got arrested is a cooperating witness. This case is called the cooperating witness paradigm. There's other types of paradigms, a confidential informant, and this falls under the cooperating witness. It has everything to do with who Fahad was and what he represented to a large segment of society, especially to the Muslim people. He was very active. He was taught in his years growing up in Flushing and going to Brooklyn College, well, you have freedom of speech and you have all these values. I didn't really believe you did. I mean, I always thought, somebody would come down on you. So but he was taught, and he would go to Times Square and put up a booth and talk about Islam and talk about U.S. foreign policy. He was quoted in Time magazine in 2002. It was an article about a speech he gave at Brooklyn College where he condemned U.S. foreign policy. And, they named the article Al-Qaeda Now, and they talked about a speech about this, Brooklyn College student condemning U.S. foreign policy. And I'm like, oh my God, how, because to me, it's like America is going to say, how dare you? And to him, he was like, well, somebody has to say it because it was the run-up to the war. They'd already been in war in Afghanistan, and, the war in Iraq was about to start. And he was at the forefront, going in front of various embassies and protesting what he felt was aggression by the Indians in Kashmir or the Israelis in Palestine. There's video of him doing that, and this is what they're going to bring in my brother's case. So this is about telling the Muslim peoples of America that, if you express your feeling of oppression and injustice, this is what's going to happen to you. Because really, a case about ponchos and socks? No. This had nothing to do with ponchos and socks. Like I said, it's about saying, well, if you exercise your right, this is what's going to happen to you. And, we're going to, put our FBI agents, we're going to put our U.S. prosecutors, U.S. attorneys on this case, and we're going to play it up for all it is. And, it's an injustice. And I recognize it as injustice. The Muslim community lives in a state of fear. Many of you are not from the Muslim community, so you don't have insight into, well, what it is like going to a mosque, because there's somebody in the mosque taking note of what you're doing. There's agent provocateurs in mosques. There's cases of people trying to rile up the congregants of a mosque. And this is what's going on. It's not just one mosque, it's many mosques. It's mosques throughout the country. And there's case after case that I can quote you. A case of entrapment for the imam of a mosque in Albany named Yasin Aref. There was a case in Detroit where Imam Luqman Abdullah, who ran a mosque in inner city Detroit, they said, well, there was a criminal investigation against him and he got killed by FBI agents just a month or 2 months ago in a shootout. He was very progressive in expressing civil rights. He was part of Jamil Al-Amin's community. Well, this is the reality of the mosques in America. And how can I tell you how it affected our family? We came here, we've been constantly moving. Our family's been constantly moving. When I say we've been constantly moving, we're part of the diaspora. Originally, we hail from India. And then, my mother's side went to Bangladesh, East Pakistan. My father's side went to West Pakistan. And, eventually my mother's side came over and we were born in Karachi. And, a segment of our family was in America, settled as professionals. And we came over to pursue what was, education, what was pursuit of, economic freedom, what have you, that wasn't, allotted to us given where we came from. And we came over, as part of a migration, a diaspora, and we had many hopes on what, I didn't want to be in this position. And what we learned was, growing up in America, we were taught that you had the right to, freedom of speech, freedom of expression, and our family was a devout Muslim family, and we practiced, we prayed at our mosques, and Fahad, took it to another level where he propagated, and so you can imagine a close-knit family. There's only 4 of us: my mother, my father, myself, and my brother, a year younger, and we had all these aspirations. And how has it affected us? Well, we can't enjoy the things in life. Like 2 days ago, it was raining, and once I was walking in my building's courtyard, the birds were chirping, and it sounded beautiful. And I'm thinking to myself, I can't enjoy this, because at the same time, 12 miles away, my brother sits locked in a room where they've stripped him of his humanity. They've got him in a room because the government says that we can put him in these inhumane, draconian conditions because we are the government and this is what we do. I mean, that's what I got from it. And how did they do this? By the passing of SAMs and secret evidence. Just to give you insight to how they're holding my brother, it's the SAMs in his case are, he's in solitary confinement, 23 hours, 24 hours, for the past 2.5 years straight, solitary confinement. In his own cell, he's not allowed to move in certain ways, or else he'll get censored. How does he get censored? By denied family visits. In his own cell, he's not allowed to move a certain way. He's not allowed to talk out loud in his own cell. He can't take a shower with closing the curtains. So this is America exercising, or this is the U.S. government exercising, what it thinks, how it should treat someone, under the presumption of innocence. Let's go back to this. My brother has not gone to trial yet. He's under the presumption of innocence. The charges against him are about ponchos and socks that somebody else had. This is the case against my brother. Let me go to the next page. Let's see. I'll be honest with you. When they told me my brother was arrested, when the FBI agents came and knocked on my door in 2006, 5 years after 9/11, it's worse to me to hear that than to say my brother has died. To me, because in 5 years, the Muslim world knows what America does to Muslims, what it does to Muslims in Guantanamo Bay. Because we know that he's in for a long haul of suffering. To me, it was worse to hear that. And you know what? It was actualized. He's suffering. They're torturing him. That's what happened to my brother. And we were expecting this because this is how bluntly the U.S. government has acted. And, there's another case of Ahmed Abu Ali, who is also a ridiculous case. He's in Supermax prison, and he's under SAMs, and, they denied him under his SAMs Jimmy Carter's latest book because it has jihadist rhetoric. The government, the Bureau of Prisons, denied him the book because it has Jimmy Carter's book has jihadist rhetoric. Another person was Zair Paracha, who was convicted in another terrorism case in New York. He's been denied phone calls. He's from Pakistan. He's a young 25-year-old, 26-year-old, 28-year-old right now. He's been denied calling home for the next 3 years as part, calling his mother. His father's in Guantanamo Bay. That's a different story altogether. And how he got there, renditioned there. So we have to place this back into context. My brother was arrested in 2006. The cooperating witness, the person that got arrested and is the main, as the government says, the centerpiece against my brother, got arrested in 2004. His name is Junaid Babar. And in 2004, when this person gets arrested, 10, 11 people around the world get arrested. People in the UK, in Canada, in Pakistan. My brother does not get arrested in 2004. They link Junaid Babar, and Junaid Babar goes into immediate cooperating witness agreement with the government, where he points fingers at people. he pointed fingers at a variety of people. My brother doesn't get arrested while he's pursuing his master's in London. These people come up on charges in the UK and Canada, and they come to trial where Junaid Babar is a star witness. This is from 2004 to 2006. My brother does not get arrested. He's finishing up his master's degree. In 2006, they arrest my brother 2 years later, and they say, well, Junaid Babar now says that he stayed with you and he had ponchos and socks in his luggage. I mean, 2 full years later. I mean, when John Ashcroft goes on TV when he arrests Lynn Stewart and says, we're rushing to safeguard America and capture terrorists right away. He went on the Letterman show when Lynn Stewart was arrested. So is this rushing to arrest someone 2 full years later? I mean, this is what's going on in my brother's case. The New York Times tells me the best and the brightest prosecutors, U.S. attorneys come out of the Southern District of New York. We had Giuliani, amongst the best and the brightest. And we have Patrick Fitzgerald, who got to prosecute Scooter Libby. The U.S. attorney that's prosecuting my brother is Brendan McGuire. He went to NYU Law. He's pretty bright. He's the son of the former police commissioner. The first affidavit that he releases against my brother while my brother was in England was he characterizes him as a Sufi Arab. We're from Pakistan. How are we Arabs? I mean, but he's the best and the brightest according to the New York Times, right? So this case in context has to be looked at about demonizing, a people, and trying to make an example out of somebody from all angles. They're stripping him of his humanity. They're stripping him, don't move, don't talk, don't read, your family visits. 33% of the time when my parents go to visit my brother, they're turned away at the door. Not because of something they did. They say, we have a bureaucratic hang-up. Our translator's not here. You can't visit your brother. I mean, they closed Guantanamo. At least in Guantanamo, you're allowed to talk between cells, right? These are one of the rules that you can't, that are imposed against Fahad. And they're bringing in his constitutionally protected speech, all the speeches that he gave. The judge, if you have ever been to a court hearing, and I know Bud, who's taking pictures, has, and a few other people have, the judge talks more than the prosecutor on behalf of the prosecutor, questioning our defense attorney. If you look at our transcript, you'll find that the judge has talked way more than the prosecutor does. I mean, what is this an indication of, We've lost every single motion to say, well, his treatment is inhumane. A psychiatrist saying solitary confinement for a day is inhumane, or a week, or 2 weeks, 2.5 years. No, the judge says it's fine. SEPA, all the secret evidence stuff, it denies you due process. No, it's okay. So is this a level playing field? No. And as I've said, before in these vigils, we're trying to salvage justice in my brother's case because he doesn't have a level playing field. He's already been, denied everything. How is he supposed to defend himself after 2.5 years of solitary confinement and not allowed to see the evidence against him? This is the reality of my brother's case. And you have a playing field where the government will introduce an expert witness who, we questioned whether this person was an expert, and, what we got back was, well, the judge says he's an expert. He's expert in downloading material, and, and he's at the government's payroll. He's never been worked on a defense case. I think Jeanne can talk much more about his expertise. She's well versed. We said, well, we have an expert witness named Dr. Fawaz Gurjis, who is a PhD from Oxford and, speaks the Arabic language. And, well, the judge says, well, I don't see the difference between the two. It's the hypocrisy, the facade of it all is just, you're watching this and you're like, okay, so this is what my brother is set for. He has a trial in the shadows of the World Trade Center with a New York jury pool where an expert witness comes who the government deems an expert, and you're going to bring all these irrelevant links about, his past speech, his past beliefs and values. His beliefs and values are in question not because we say it's in question, it's because the prosecutor and the government And the judge says it's in question. In the bail hearing, three and a half years ago, we said, the prosecutor gets up and goes, well, this person who's never been arrested in his life and, has a, academic background, well, you can't give him bail, judge, because, he believes Allah's law is superior than man-made law or American law. And, judge said, kind of winked and said, well, I certainly don't want to curtail anybody's beliefs and values, but really, can we give him bail? When did that become a criterion? Somebody that's never been arrested and his beliefs and his values? We didn't bring it into the discussion. They did. They brought it into discussion, and this is what the whole discussion is all about somebody expressing their values and beliefs. The two audiences that this trial plays to is to the Muslim audience and to the American general public at large, to say, look, we're keeping you safe by protecting you against guys like Fahad. We're spending $80 million of budgets in New York City for these terrorism cases and keep you safe. And as David Cole puts it more eloquently than I could, less safe and less free is what they're actually accomplishing by perpetuating the injustice. So, that's it for me. I think I'll leave it up to Shane to talk about Guantanamo and the new paradigm that we're witnessing.
Okay. Well, thanks, everyone. Again, my name is Shayana Kadidal. I'm the head of the Guantanamo litigation project at the Center for Constitutional Rights. I've been doing that for about 3 years, and for about the 5 years before that, working on Turkman v. Ashcroft, a case on behalf of the people caught up in the immigration sweeps just after 9/11. We've heard an awful lot this week about the prospect of Guantanamo physically moving onshore. But as the previous speakers have said here, an awful lot of elements of the Guantanamo system are already here. And this particular case illustrates a couple of them, and I'd like to talk about 3 of them. Some of this is stuff that Jeanne has already touched on. But the first is guilt by association. The second is kind of the excessive secrecy that's kind of been dropped around these proceedings. And the third are conditions of confinement, supermax conditions of confinement. At Guantanamo, an awful lot of our clients were swept up in profiling. Instead of being an Arab man who wasn't documented and was from either South Asian or Arab country, as happened, in Brooklyn after 9/11, it was very typically you were a foreigner in Afghanistan or crossing the border with Pakistan or inside Pakistan. And the government was paying huge bounties for these folks. Pakistani policemen and rival warlords and hungry villagers brought them in, turned them in for 20 years of wages. And often their detention was justified once they got to Guantanamo on paper based on their purported associations. So there'd be an allegation somewhere from some witness saying this person stayed in a hostel where a lot of other foreigners were present, and some of those foreigners had some link to Al-Qaeda, and that's why we can hold them. And if you look at the small handful of Guantanamo detainees who were charged, all but 2 of them had material support charges, the sort of charges that typically verge on guilt by association in their charge sheets. What is this material support violation all about? Most people have never heard about it, or certainly before 9/11 hadn't heard about it. Basically, the way it works is this. The government creates a list of designated terrorist organizations, and then once an organization is on that list, any form of support for the organization becomes a criminal violation, a pretty serious one, punishable by 15 years in jail to start with. And those forms of support can be not just arms or money, the kind of conventional things that you would think of as support for a terrorist organization, but providing personnel, often in the form of yourself, or training, or expert advice and assistance, whatever that means, or services, the most open-ended category there. This is really kind of modeled on the traditional sort of offense of conspiracy, but it's a more strict liability version of it. What do I mean by that? Well, conspiracy is the crime of planning a future crime, essentially, agreeing to carry out a crime in the future. John Ashcroft used to love to say that, the new post-9/11 paradigm is we're about preventing criminal acts from taking place. And that's why we're not going to prosecute anyone at Guantanamo, because we have no mechanism for actually prosecuting future crime. Well, conspiracy is the traditional method of prosecuting future crime, and it was always subject to prosecutorial overreach. But there were two features of it that were built in traditionally that were designed to curtail overreach. So in order to convict someone of conspiracy, you had to show that they had joined a group of other people and agreed to carry out some criminal end. So they had to have intent to further that criminal purpose. That's one requirement. And in order to tangibly show that intent, you had to show that they carried out some sort of act, an overt act is how the law describes it, that helps further that end. It helps carry out that criminal goal at the end of the conspiracy. What material support I called a strict liability version of conspiracy, and what this means is it kind of takes away that requirement that you prove intent to carry out the criminal end of the organization that you've joined. So the only intent that the government has to show under the material support statute is that you knew that the group was on the list. It doesn't matter if you had any intent to further the criminal ends of the organization. So Hamas is on the list. If you wanted to give money to build an orphanage or a school in the West Bank, and you did that, or I suppose Gaza is a better example, but and you gave money with that intent, it doesn't matter as long as you knew that the group is a designated organization. And you end up being punishable by these extraordinarily long prison sentences. Well, I mentioned a couple of the categories of what can qualify as material support. So services, providing services, or providing personnel, providing anything where you can be characterized as as personnel that you've provided to the organization. Well, these things are very vague by their nature, and they may blur over into the sort of advocacy that's protected by the First Amendment. So what if you are speaking out in favor of the Kurdistan Workers' Party? Well, that could be providing yourself as personnel. It could be providing a service to the Kurdistan Workers' Party. The common sense understanding of the law is very vague, and it definitely seems to step on things that ought to be protected by the First Amendment. We have a case at the Supreme Court right now. It's going to be argued on February 23rd, challenging these aspects of the material support statute, and there's a great friend of the court brief that was filed by a whole bunch of children of Hollywood blacklist victims talking about this point, and another amicus brief describing by peace groups, humanitarian aid groups, talking about how much aid has been forgone in conflict zones because of the existence of this material support statute. So, for instance, people who wanted to go teach human rights law and the enforcement of human rights to groups like the Kurdistan Workers' Party or the Liberation Tigers of Tamil Eelam, which controlled a large swath of Sri Lanka until a year ago. People who wanted to promote nonviolent dispute resolution, people who wanted to give textbooks on federalism to the Tamils, people who want to do charity, medical assistance, sort of infrastructure reconstruction in areas that are controlled by designated groups, like that eastern shore of Sri Lanka that was hit so hard by the tsunami. All of these kinds of forms of humanitarian aid and political advocacy are areas that you'd almost have to be crazy to engage in given the existence of the material support statute. And as Jeanne mentioned, the Supreme Court decided a number of cases in the 1950s and 60s about association with bad people. Well, oftentimes those bad people were the Communist Party, an international conspiratorial organization designed to undermine and overthrow not just the United States government, but our entire way of life, right? With sleeper cells planted in the United States. And the court said, well, you cannot criminally punish membership in the Communist Party unless the person joins with the intent of furthering the criminal ends of the party. And that's extraordinarily important principle about what we call vicarious liability, being punished for the criminal acts of somebody other than yourself. This is really at stake before the Supreme Court and in cases like your brother's. Well, the second feature of Guantanamo that I wanted to talk about is this idea of sort of secrecy and of restricting the detainees' communications. Now, at Guantanamo, some of you may be familiar with this. Everything that our clients say to us is presumptively classified. So we take notes, and at the end of the session, meeting with them, we hand them over to the government. They go off to a Justice Department privilege review team. They read them to decide if anything in there is unclassified. If it is, they fax it to us in our offices. If it isn't, which is pretty much the case for everything that's important in the cases, it goes and sits in a secure bunker in Washington, D.C., and we have to go down there to write our briefs and to scribble notes. And if we have a great idea, and we wake up in the middle of the night that we can use in the case based on something they've told us, can't scribble it on a notepad next to our bed. We have to go take the train down to D.C. and type it up on a government computer down there. Domestically, the kind of rough equivalent of this are these special administrative measures, or SAMs, like we have in Hashmi's case. here. Now, the regulations that govern these were passed in 1996, same time roughly as the material support statute was created. And they say they can be used by a judge when allowing communications with the outside world by the person in detention would create some sort of risk of death to persons on the outside or damage to people or property. Now, on these allegations, that's absolutely nuts, and I guess that's the first point that needs to be made here. You can see it maybe for spies, the kind of classic SEPA graymail situation where someone's been, alleged to have been working for the United States for a long time, and then it turns out that they were actually passing secrets to some foreign government. Well, yeah, you might want to restrict that person's communications with the outside world on the premise that they, might continue to leak information to a foreign government from their prison cells. But here it just doesn't make any sense on the allegations. The problem is that judges are typically extraordinarily deferential to things that government and prosecutors come into court and say. I mean, why does a judge want to take on the risk of something going wrong? This sort of situation, much like prison conditions that the government claims are necessary for the security of their guards or other reasons like that, judges tend to not want to sort of interfere. And so what you see oftentimes is really extreme measures put in place and then left there for years. Richard Reed has been in solitary for 6.5 years, I believe, and just got moved to general population. It really takes an awful lot for events to prove to the judge that the initial fears were completely misplaced. And, what happens with this, unfortunately, is that it also carries over into a complete lack of openness at trial. Thanks. And this idea that we should have trials out in the sunshine is not just an abstract philosophical principle. It has a very practical effect on the truth-determining function of court proceedings. So the Supreme Court in the early 1980s said in a number of rape shield cases that open proceedings, are usually more accurate proceedings. They can bring new witnesses out from members of the public who are, sort of following the proceedings. They give people who are testifying already a disincentive to carry out perjury because they know everybody in the public might be listening and someone might expose their lies. A very typical problem for the government when what they have done in an alleged conspiracy case is pick out the biggest liar, as they usually do, and try to convert him to state's witness, right? The third thing is that it makes all parties involved, including the judge, more conscientious about carrying out their duties rigorously, fastidiously. And we see all this dramatically on display in the Guantanamo cases. You've probably read in the newspapers that there are a number of detainees at Guantanamo who decided to cooperate with the government and have implicated huge numbers of fellow detainees. The Washington Post reported that one person implicated over 60 other detainees. Now, I can't confirm or deny any of that, which is our usual line about things that might be or might not be in the classified factual returns. But the Washington Post says that there are witnesses there who've gotten PlayStations and a stereo, all sorts of other electronic equipment in their own apartments at Guantanamo in return for implicating huge numbers of their neighbors. How do we find this out as lawyers? Typically, it's by walking from office to office in that secure bunker where the classified information is held and talking to other people because we have no real mechanism for sharing information in the ordinary way that lawyers do. We can't email each other about who's implicated our clients from our offices. We in fact have a drawer in the secure facility where we dump little sheets of paper where people have written lists of who implicated their clients so we can compare notes. But that's something that puts us in terms of kind of our being present in the electronic age, way behind some of these alleged mass implicators. We're in the 1950s, and they're in the 21st century in terms of electronic goods. In terms of conscientiousness, I think we've seen that in the Guantanamo cases too. I think very often that one reason the process is moving so slowly, one reason the judges are so unwilling to challenge the government's case is because reporters aren't usually sitting in the audience for these proceedings. There are plenty of times where I've left a closed hearing thinking, God, this judge would move this process along much more fast if the reporter from the Washington Post who covers a district court beat wasn't sitting downstairs in the cafeteria trying to glean information out of us, but was actually allowed to be there in the audience. And I think we'll probably also see an awful lot of that here too, since SIPA allows parts of proceedings to be closed, and those are usually the very most important parts of the proceedings. Finally, the third aspect that we see, where we see parallels between domestic criminal process and Guantanamo, are these supermax conditions. Now, you probably know that most of the detainees at Guantanamo, about 95% of them weren't captured by the U.S. Armed Forces, and in fact weren't captured anywhere near anything resembling a battlefield. But the government has always claimed that they are prisoners of war in some sense, and POWs are supposed to be held in non-prison conditions. They're not supposed to be held in cells. They're supposed to be held in barracks. The comparison I always use for this is if anybody is old enough to remember the cheesy TV series Hogan's Heroes, they all lived in big dorms. That's the norm for prisoners of war. And at Guantanamo, one of the starkest departures from prisoner of war conditions is the fact that more than half of the detainees still are in solitary confinement in what are called camps 5 and 6. Two supermax facilities modeled brick for brick on the blueprints of two supermax facilities within the United States. What does that mean? Well, we've heard some of this already, but just to repeat a little, it means you're in your cell typically 23 hours a day. Your cell's 6 foot by 9 foot. You have no natural light. You're constantly surveilled. The lights are on almost all the time in order to facilitate that constant video surveillance. You have the smallest possible window, usually about 3 inches by 2 feet long, to the interior of the facility, usually frosted over because some judge, in some case in the domestic context, decided that was the minimum window that was permissible to allow someone to be humanely detained. You have recreation often in what we call sort of air shaft outdoor pens. So, for instance, some judge decided at some point, presumably, that it was important that detainee be allowed to be outside. So what's the most technical definition of outside you could come up with? Well, in Pelican Bay, California, you've got a prison where all the rec pens are in the middle of the prison, and while you can see the sky overhead, you have to look up through walls that are sort of 3 stories high, so it's almost like a little air shaft. You get exactly the same thing at Guantanamo, again, because all these prisons are modeled on each other, and they're all designed around what some judge said was a minimum humane acceptable standard. Everything is sort of this race to the bottom. At the MDC in Brooklyn, I don't know what the MCC is like, but at the MDC in Brooklyn, it's about 9 stories, I think, high, and there's the rec pen on the roof of the building, which I guess is the only place they could get something outdoors. And actually, it's got 3 stories or so of chain link around it. And on a tour there, the people giving the tour told us, well, that's so you can't have helicopter escapes during recreation time. That's another example of Hollywood setting a detention policy. We can tell now that when our clients are not just given rec in these little pens, but brought out into the front yard of Camp 6, as has happened since Obama's been president, because they're much easier to talk to when they're a little bit tan, and it's remarkable how the mood parallels the amount of exposure to sunlight. Well, who came up with this sort of idea of keeping people in supermax detention? Well, the Quakers were the first people to implement Jeremy Bentham's idea of keeping everyone in a prison in solitary confinement. The idea was, well, it'll just be you and God as opposed to you talking to your delinquent peers in the next cell over, right? And study and quiet contemplation will be much better at rehabilitating people. Well, they built this facility in Pennsylvania, Eastern State, in 1829. It was an utter disaster. Everyone went nuts into either catatonia or rage. And this idea was sort of put on the shelf and not brought back for a long time until the 1970s, when the combination of the crime wave and prison overcrowding that it produced created this idea of very violent sort of people who are already in prison and carrying out more violence in prisons. It had to be segregated somehow from the rest of the population. It also created this idea of the sort of super predator criminal, someone who's far more dangerous than the ordinary criminal. And so, given that myth, states started building these supermax facilities that we see now. It was a very popular kind of thing for politicians then and today. It proves that you're tough on crime, right? If you build this facility and you can bring cameras around it and see how state-of-the-art and sort of high security it is. And, of course, once it's built, you need to find some people to fill it with. And the first people to fill it with back in the 70s were prison gang leaders who were often black radicals or jailhouse lawyers very frequently. And you see exactly the same thing going on in Guantanamo. So just to bring out one prominent example, detainee who's been in solitary since 2005, Shakar Amir, an English resident, was one of the leaders of the other detainees, was the emir of his cell block, the guy who would negotiate over conditions with the people who were heading the entire camp. Shakar, we all learn his name pretty quickly because his name is on all these petitions as next friend to other detainees. He was a guy who lined up contact with lawyers for all sorts of other detainees because he spoke English. He was, his family members got in touch with us and people visited him initially, and he found lawyers for hundreds of other detainees. As a leader, that's not a popular thing. That doesn't make you popular with the people running the base, and he's been in solitary for 4 years. Psychologically, it's extraordinarily damaging, and this is hard to illustrate because it doesn't leave any scars, and anybody can stand being in solitary for a while, right? When the weather's terrible, I stay in my apartment all weekend sometimes and don't see another person, but and some people feel like, well, 2 weeks or 3 weeks, I could, I've done that in the past. People in the hospitals do it, people in space travel do it, right? But there's never been an academic study of people who've been detained for more than 90 days in solitary confinement where it hasn't resulted in serious psychological problems for everybody who's been detained, which is remarkable consistency, and yet the fact that people have different levels of sort of tolerance for it makes it very difficult to explain to the general public why this is so pernicious. But out of everything that you've heard about what happened at Guantanamo, from the physical brutality to the sexualized interrogation techniques to the sleep deprivation, all the rest of it, all the the exposure to cold things designed by the North Koreans for use in the 1950s, all these sort of horrors. Isolation is by far the worst of it, and all the sort of torture experts we've talked to have said that the damage that isolation causes is the hardest to reverse out of all of these kind of things. We even see it for the guards. One of the most sort of compelling little facts about isolation is that at ADX Florence, the big supermax facility where most terrorism convicts in the United States are eventually sent, a lot of the guards there have been 9 guard suicides, which by far outpaces the number of suicides among the detainee population there. And some of the guards would say things like, every time I'm in a restaurant, I sit with my back to the wall so I can see who's coming in. Nothing good ever happens in your interactions in a supermax facility, and therefore you start to, sort of dread, anything ever happening. The reality is it is a huge problem for pretrial detention, like we have in this case here, because it makes it impossible to work with your clients. So we see this at Guantanamo. After they've been in solitary for a couple of weeks, all they want to talk about is alleviating their conditions of confinement. They don't want to talk about the substance of their case anymore. And the other side obviously knows this. And so, all of these things that we've been over today, and in particular the supermax conditions, are ways of leveraging pressure onto people who are in this kind of these horrible pretrial conditions to plead guilty. And this has happened a lot at Guantanamo. You've seen people cut deals in the military commissions, even though their process probably wasn't going to go forward very quickly, to put an end to their horrible conditions of confinement. The Lackawanna Six, a group prosecuted in upstate New York, were told they might be taken to Guantanamo if they didn't plead guilty. And pleas are at a huge premium in material support cases, precisely because despite the fact that in a formal sense it seems like it should be very easy to get convictions on a strict liability crime like this, juries often look at these cases extremely skeptically. A jury is not going to think, well, the group was on the list, you probably knew the group was on the list, I guess we have to convict him. They're going to think socks, right, and ponchos. And if you look at the 120 material support cases that have been brought since the statute passed in 1996, there's only a 50% conviction rate, which is extraordinary because in the federal system, the conviction rate is somewhere around 99.2% if you factor in pleas. So there's a tremendous amount of interconnection of these legal issues, of things that are at issue at Guantanamo and here domestically. And while all the attention right now is overseas, focused on our favorite island prison, the same weapons are aimed squarely at radical political organizing here at home.
So we want to open up the floor for a larger discussion. So to do that, we'll take, say, 3 comments or questions at a time, and then we'll give the panel a chance to respond. With that.
In Fahad's case, was there a habeas corpus action taken in the last 2.5 years? And what was the outcome of that?
I don't think habeas corpus was taken because it wasn't necessary. He's been produced. Everything besides all our motions for his SAMs to be thrown out, for the SEPA, elements of the SEPA to be thrown out, those things were denied. The motions that we're talking about are, if not throwing out the SAMs completely, lessening them. And no, none of that was approved by the judge. We've had 20, 30 hearings where Fahad has produced various different motions about his confinement and the SEPA. Every single thing has been denied.
I guess what I'm really asking is it necessary to prove this person has not been put on trial yet? This is a pretrial detention. It's an extremely long pretrial detention. It seems that that's quite extraordinary. That you would not, an action could be brought, or what sorts of actions have been brought to show the unconstitutional nature of a 2.5-year pre-trial detention. And I don't understand how this can be happening.
Can we take that and then add a couple more questions, comments to it, and then have a round of responses?
I have two questions. First is, Shane's talking about the level of, call it what it is, torture via solitary confinement. The UN has come in a number of times with supermaxes, my understanding. They've done reports on the supermaxes, said that they're in extreme violation. I guess my question back is, so what's the U.S.'s response to that, and how do they get away with it? Considering that the UN, much higher than the UN, has had these reports on the supermaxes. And the second question is, have there been cases? Have there been cases against SEPA? And I know in Fahad's case, there have been questions about the SAMs, motions brought about the SAMs. They've all been turned down by the judge. But what could a case against the SAMs themselves look like? Is that something that could happen in the future? Because it doesn't seem like there's any other way around these things than actually taking the SAMs themselves to court.
Well, they sound like linked questions and comments, so do we want to deal with those before moving on?
I think one of the interesting things in terms of, I think partly what you're getting at is the whole speedy trial issue, no? And how we can have 2.5 years of Fahad being an MCC before trial. And I think one of the things that I think is very disturbing is the ways that you have to, within the system, give your own rights away. So, because the evidence is classified, it requires the lawyer to get a clearance to see it, right? It took the lawyer almost a year to get the clearance, right? So what effectively that meant is that Fahad's defense had to keep saying, to keep eliminating that time in that first year, even though it was the government taking the time to clear the lawyer, right? What you have to do in court is you get up and you say, we will basically throw this time out between January 2007 and November 2007 for speedy trial provisions, because in order to prepare the case, the lawyer needed to see the evidence. In order to be able to prepare the case, even after the lawyer got clearance, there was what the government describes as voluminous evidence, right? So there's this way that, one of the kind of I was trying to stress this, is the ways that so much of this comes kind of through the process itself. So you literally have to give your own right to a speedy trial away to get a slightly more fair trial. And so now we're 2.5 years later, right? Because you have to agree to, I forget the word. What's the word where you exclude this time, right? Is that the word? From speedy trial? What's the legal word?
I should know. We just submitted a brief on this.
Exclude, right. And so I think part of it is that's how we're 2.5 years later, is partly because because of the tremendous amount of time to get both cleared. All of these things take all this time. Meanwhile, Fahad's sitting in MCC, and yeah.
I mean, just to focus on what you said, to get cleared from the government, so they could have done it in a day, 2 days. They took 7 months, 8 months. So, that's the lay of the land.
Mm-hmm. Yeah, it's a little known secret that they can give you an interim clearance even at the top secret level with purely electronic checks, fingerprint, criminal background, and credit. In half a day if they want to. They never do. In terms of international standards, Amnesty International has a great report from about, I think maybe late 2007, early 2008 on the supermax conditions, and everything about the U.S.'s detention policies generally doesn't comply with international standards. Our sentencing is generally extraordinarily long. We have, this enormous prison population. Most cells in solitary are way too small. You can just go on and on and on, but the only thing that really counts is what the few district courts that have dealt with the supermax phenomenon, mostly in the last 30 years, have decided are the absolute minimum, and we really haven't gotten very good. We haven't gotten many rulings at all from the courts of appeals, and they certainly, there aren't a lot of great rulings out there. Like I said, the first judge who says anything about what's minimally acceptable ends up being treated as a design Bible, really, And one of the most interesting talks I've ever given in the 8 years I was at CCR was a talk to a group of architects encouraging them to boycott the design of these facilities on the grounds that you really can't design a good isolation facility that will not produce insanity. It doesn't matter if the cell is 11 feet by 8 feet as opposed to 6 feet by 9 feet, or if you have a little more sunlight. It's the aspect that doesn't seem inhumane, the isolation, that is the worst part of it. I forgot what your second question was.
What would a case against the SAM
look like? What could it look like?
I mean, the tough thing is there's so much deference, right? And so how do you get around that? You have to sort of slowly build a factual record. So typically it occurs in the context where someone's convicted and they're subject to them for a long, long time. And so you either have a track record of the deleterious effects of the SAMs on the individual, or of the fact that all the sort of security concerns that the government claimed at the outset were BS, one or the other. The problem is it just takes time.
I think there's some possibility also around the process. When they implemented them in 95 and 96, they had some comments process, and a lot of constitutional questions were raised. But they very much did change. In 2001, when they expanded kind of when you can use them, and then change the standard for renewal, there was not really a comments process. So I think some people have thought that maybe there's also a possibility to litigate through that they're, similar to what the setting up of communication management units. One of the ideas for litigating that has been that there wasn't, again, there's supposed to be this place for the public to comment on these things. And so it may be that it could come through there. The other interesting thing in terms of Europe is that Britain is now holding up a number of people the United States is seeking to extradite precisely on conditions of confinement. That they're now that they're not always willing, and we're starting to see this perhaps possibly throughout Europe, that because of these supermax conditions that you're seeing Britain now being very reluctant to extradite people the United States wants under, because they say this violates their own kind of human rights law.
Babar Ahmed is a British prisoner waiting extradition to America. He was charged in America for something, and he was arrested before my brother. He's still being held up, and Babar Ahmed goes, well, look at Fahad Hashmi's case and the SAMs that he's under. And that's what, I'm a British citizen, and, this is inhumane by every standard. So, and Gareth Pierce is his lawyer in England.
Yeah. Usually
take another round of questions. Anyone else have? Yeah. So do 1, 2, 3. Yeah.
We're talking about violations of rights tonight. Coincidentally, a few days ago, I heard an author speak who is a lawyer, and he just wrote a book on the assassination of the Black Panther, Fred Hampton. And it took them 13 years to go through all the documents in the case. But it was made very clear that once the people in power in this country, real power, perceive you as a threat, the Constitution goes out the window and loses any kind of meaning. And it seems to be happening more now. It's always happened, I guess, but it seems to be more so now. And what makes it particularly frightening now is that we seem to be in a permanent state of war. So anytime anyone questions anything, they're perceived as an enemy. And I guess this is directed at the lawyer. How do you handle this?
So let's take the two other questions and then we'll respond to all of them together.
I really also just want to say, a word of thanks to the Theatre Against War Pro and the, civil educators for civil rights for doing such a great job, I think, with mobilizing on this for Fahad Hashmi's case. And I was just wondering, what is the kind of mobilization sort of in the South Asian American community, and what has been the response? What is the sort of strategy looking ahead in terms of the hearings on January to kind of sort of, make sure that, there's going to sort of really win this fight? Because there's always kind of this risk. I mean, we've got wonderful sort of petition. We've got sort of luminaries, scholars, all over the country who have signed the petition. It seems that there's a lot that, that's been done to really fight this case. At the same time, one really wonders, but you see other kinds of things, back in history, like, I mean, just not even back in history, in our, present times, like Mumia Abu Jamal, the kind of mobilization, and is still in prison. It's like, how do we, make this a victory?
Let's take the third.
Yeah, I'm from Iran and my English is not that good. I was a little late, so I'm trying to understand what went wrong, what was wrong with him, and so on. It seems like he seems to be a good boy, and he didn't do anything wrong. So the only thing I see is that he had this Al-Qaeda guy in his compartment, right? Am I correct?
Finish your question and then we can go on.
Then they're going to respond to all of them together.
If I did understand correctly, the only thing that the government can accuse him is that he had a guy in his apartment and he had connections to the Al-Qaeda, right?
So clarifying exactly
is it
what
really
the
true?
issue is.
And did he know that this gentleman stayed with Al-Qaeda? So that's, for me, it's important to understand the whole thing.
So let's
start in
who
order.
would like to jump in first?
Well, I mean, on your question, if I knew how to deal with the war mentality and get people past the model, I would have put myself out of business already, I suppose. I really don't know that there isn't necessarily an easy answer to it, other than eventually, time passes and the crisis mentality can really only perpetuate itself for so long. And it's an open question, really, whether that is what's happened since 9/11. Or as some of the kind of advanced polling data that has come out of left organizations like OSI would say that in fact what's happened is that other sort of crisis issues have come along and have pushed down the salience of what people believe the terrorist threat is, and that in fact people hold all the same views about terrorism as they did right after 9/11, but the economic crisis and the war in Iraq, which people regard as a separate sort of thing, or in Afghanistan, that those are kind of higher level concerns now. I think, for my own money, I think, one of the best approaches we can take to this is really, something that's regarded as a little more conservative approach to arguing these issues, which is to show that almost all these measures don't work, that they aren't calculated to reach the truth in trials, that they aren't effective, as counterterrorism, either in the big picture of sort of winning hearts and minds, or in the small picture of sort of, being effective techniques to root out conspiracies, which law enforcement has, been doing since the beginning of time, and the ways that we're going about approaching it are just all wrong. according to the ordinary handbook. I think if we convince people that all this stuff doesn't work and produces bad outcomes in the sort of net long term, that you can kind of crack through that shell of, well, this is trading off liberties for securities, and that in fact what's happening is that we are both less safe and less free. I think we've got to convince people that it's counterproductive ultimately in order to reach the people who aren't hearing all our other messages, because they are convinced that somehow there's a huge threat out here and they're willing to trade away this much in the way of liberties, especially when it belongs to somebody who doesn't look like them, in exchange for some tiny marginal gain in security. I think if we can convince them that in fact they're getting a loss in security in exchange for all that, then maybe they start to listen to all the other sort of stuff about betraying traditional American aspirational values and all the rest of it. So, do you want to talk about that?
Sure. I can couple both of those. In regards to the person that was arrested, as I'll answer that first. Just the cooperating witness. We have this person was an American citizen that left America in 2001, and he gave an interview in Pakistan in 2001. He lived in and where he denounced America and all these type of things. But you know what? In 2001, when he did all these radical things, Junaid Babar in Pakistan, he was not arrested in Pakistan. They're knocking on Muazzam Beg's door in Islamabad, saying that you lived in Afghanistan, and renditioned him to put him in Bagram. So this person from 2001 to 2004 lives his existence in Pakistan, apparently saying radical things and doing radical things. Neither was he arrested by the ISI, neither the American soldiers came into Pakistan and arrested him. He said some radical things in 2001. In 2004, this American citizen flies back to America after, they said he stayed with my brother. In 2004, when they arrested him, there's a case called Operation Crevice in England. It was the most expensive British legal case in history, where they said that Junaid Babar, while he was in England, was followed, videotaped, surveilled, like you can't imagine. That all these resources were spent on Junaid Babar. This is not me saying it. This is the British government, all the British newspapers saying, and they said, the British government spent their whole time monitoring this guy in a plot in England in 2004 while he was staying with my brother. Again, my brother doesn't get arrested in 2004 because the British government, says there's no case against my brother, neither in that instance or anything else from 2004 to 2006. So if the British government didn't arrest him in the most expensive case up to that point in British history, where they had this guy on video for surveilling him the whole time he was there with my brother, right? And there's many statements that this guy makes in open court in these cases. Well, I didn't tell Fahad anything. He's not part of anything. This is what he says in his testimony in these cases. So the British government doesn't have a case. The U.S. government in the recent motions eliminate are saying, well, there was a case in England, and Fahad knew these people that were arrested in these cases through Junaid Babar. If the British never brought charges against him, the Americans are making implications to it in their case against Fahad. So who is this person? You can read all about him from the various statements that he makes himself, where he says, well, I'm a liar, I'm an admitted liar, I'm a thief. This is what he says in the open court. When he was arrested in America in 2004, when he flies back to America and gets arrested, the FBI doesn't arrest him in the natural way. They say, okay, we're arresting you. Let's go to the embassy suites in downtown Manhattan, just a few blocks from here. We'll keep you there for a week. He waives his Miranda rights. He's facing a 70-year prison sentence himself. This is why he's called a cooperating witness. They basically said, okay, point us people, and your prison sentence is thrown out the door. That's what he says in open court. He goes, I expect to walk out. His prison sentence is thrown out. He's the cooperating witness. Again, 2004, 8, 10, 11 people around the world get arrested. Fahad doesn't get arrested. 2 years later, they arrest my brother. So this is the context for my brother's case.
What was his relationship then?
He was an acquaintance of my brother.
What means acquaintance? Friend?
Yeah, he was someone he knew from New York. This is not like not public knowledge. It's not somebody that he didn't know. What's interesting is, and I'll go back to what Bud's wife, Fran. What Fran talked about, the kind of individual this person is. You talk about the assassination of Fred Hampton, and let's go back to, I heard the same author speak on Democracy Now! Willie O'Neill, Fred Hampton's friend, was the one that gave him the layout plans to assassinate Fred Hampton, and he was an agent provocateur. So, let's make the correlations if we can, right? What type of individuals? Willie O'Neill was Fred Hampton's friend. He's the one that told the authorities where Fred Hampton was sleeping and to shoot upstairs and shoot this way and shoot that way. And this person is a cooperating witness facing 70 years in jail who says in open court, I don't think I'll be in jail anymore. My wife and kid in Pakistan are with me here in America, or something to that effect. And my sentence is gone, but Fahad is the one facing 70 years in jail for ponchos and socks that I had in my luggage. I mean, that's the context of it. Go ahead.
And then I think we want to talk about the organizing and sort of where to go from here. The trial is set to start on January 6th, which means they will pick a jury on January 6th, and they expect it to last about 3 weeks. So the very most important thing to do now, if you can only do one thing, is to come one of those days, right? So it's going to start January 6th. It's taking place at 500 Pearl, which is the U.S. District Court. It's taking place in Judge Preska's courtroom, which is on the 12th floor. So again, if you can do one thing, if you can come again for part of a day or a whole day or just an hour or two, right, to make sure that courtroom is full and so that jury sees that the people of New York are watching this case. The second thing is, as Brian mentioned, we are having vigils every Monday night from 6 to 7 outside of MCC to be a kind of visible presence here in Manhattan around these conditions of confinement here in the United States and here in New York. Because I think most New Yorkers, most Americans don't have any idea, right? So again, if you can come out on a Monday night from 6 to 7 after work, I know that's an easier time for people. That's the second thing. And then the third thing that I am asking people to do personally is we have had a lot of trouble. The media is not so interested in these kind of domestic issues and in looking at these cases in any kind of systematic way. And so I think we need to be putting pressure on the New York Times and the Washington Post to be looking at, more systematically at kind of civil rights and civil liberties here within the courts. And that again, the Post and the Times are running like an article every day on the sort of Guantanamo detainees being brought back and all these different and they have yet to run a kind of systematic piece, they're doing some interesting kind of trial by trial, but not kind of linking a kind of broader pattern or kind of showing these things in the kind of broader landscape. And so I think we need to be writing letters to the editor, writing emails to various reporters at the Post and the Times, asking them to please turn their attention to sort of what's happening in the federal courts, and that sort of there are significant civil rights issues in the federal courts that they have not kind of shown a light on. So my personal third plea in terms of things you can do is, again, to be putting pressure on the Post and the Times to be covering these issues, again, more systematically.
And would anyone else like to comment on how we take some of the understanding that we have gained tonight and throughout working around this case and turn it into a victory or move
and also
further in that direction?
the extent of mobilization of the South Asian community and what's been the response?
Okay, so the South Asian community or the Muslim community in general have been living in a extreme state of fear. When this happened, it was like nobody wanted to talk to us, and what we had tried to do in our efforts, with the Free Fahad campaign, was we went to mosques. We went to like 15, 20 mosques we had a lawyer and we had an Islamic speaker. The lawyer enlightening them about the case, about the larger civil rights issues, and the Islamic speaker talking about from the Islamic perspective how we're supposed to deal with this particular case and these cases in general in support of Muslims that are being oppressed. And that has worked to a certain degree in this community. I mean, it hasn't worked, in terms of like everybody and their mother has heard of this case, but to a certain degree, we've been able to raise a certain amount of awareness and try to enlighten the Muslim community. When people knock on your door, they don't knock with good intentions. And, you should always have a lawyer. So these are certain things that have, kind of panned out. The South Asian community is frightened. The Muslim community is frightened. But at the same time, they're also, very fed up with this harassment, this state of this atmosphere that's being constantly perpetuated. So there's been 5 or 6 major cases in the past 6 months of Muslims being arrested. 2 entrapment cases, one in Dallas and one in Springfield, Illinois. Another entrapment case in Riverdale, where a confidential informant was recycled, the same one they used in Albany. I mean, this is constantly going on. There is a case of a white Muslim family in North Carolina of Daniel Patrick Boyd. And, what does the media harp on? Daniel Boyd's Muslim name is Saifullah. And it was like, well, his name is Saifullah, meaning the sword of God, and that's a terrible name and all this. It's a very common Muslim name. I mean, so these are the kind of things that are happening. At the same time, within our community, we have gotten a lot of support. A lot of people have come out to the court cases. At least 50, 60 people at, per hearing. We've had hearings where we've had 100 people. And we need everybody to come out because it's an abridgment of, once it starts with our community, the Muslim community, it goes over to any other community where the government tells you who the radical speaker is and who the radical person is. This person went, listen to this radical speaker. The government is defining everything for you. And that's just 1984. So
we're going to have to wrap up. Maybe just a couple of brief comments. Try to keep them as concise as possible. So 1 and then 2.
Okay, just about law school in general. Integrity, courage, I guess. You have, what is the status of the law schools right now? Like this Judge Prescott? Where did he graduate from? Is there any, where his, have any say in all this? And also, if I understand right, again, like in any profession, there's good and bad. So you're saying get yourself a lawyer, and hopefully it's a good lawyer or a decent lawyer. But half the graduates from law school then join the DA's office. So is it, aside from their personal beliefs, unless they, or the integrity, if their head prosecutor is saying to their lawyer, their DA, whatever, junior DA, well, you do this and you do that, is there any kind of, I guess, accountability for the people in the law system itself?
And one last.
In addition to all the things that the panel encouraged us to do, which I agree with very much, the other thing to remember is to build the movements that the government fears so much, and to make clear to the people in those movements for social justice, against war, etc., that they have to support the prisoners and vice versa. The prisoners' movement supporting those movements. The other thing is that I agree very much with the last point Jeanne made about the terrible coverage, but it's even worse than that in the sense that in the recent cases, the recent frame-ups of the last few months, there's now gelling a pattern of media coverage where they're being labeled as, without any evidence, usually even any charges, as being, fighting with the terrorists. And we have to squash this homegrown American terrorist phenomenon, and that must be countered in a very explicit way.
So I feel like there's definitely this continued sort of open-ended question of how to further mobilize, how to continue to move in a positive direction. I want to give the panelists a chance to make any last remarks, and then conversation can carry on in an informal way afterwards.
Well, there's long been this kind of paradox with the role of prosecutors in our society. I mean, they are, on the one hand, supposed to be a little bit like judges in the sense of sort of having higher ethical standards applied to them in the way they go about doing their cases and selecting cases and reporting facts to the court and so forth. The founders debated for a long time, should they put the prosecuting arm of the government in the judicial branch and have it be, as immune from political pressures as judges are supposed to be, or should they put it in the executive branch? And at the end of the day, they put it in the executive branch because they wanted people to be able to vote out the person who was the, kind of commander-in-chief of all the prosecutors. There are a lot of interesting ways that this plays out, right? I mean, you could see, political accountability for enforcing unpopular laws like, the drug laws, being sort of reflected in less enforcement in an ideal world. So there's that kind of trade-off and paradox there of, on the one hand, we wish prosecutors would behave more independently from political pressures, especially in cases like this that are highly politicized because of all the media attention that goes to them. In other respects, it's a good thing to have a political check on it. I don't know, there's a very good structural solution to that.
I mean, I agree with your point around, I think I'm sure many of you saw it, Scott Shane had a front page news analysis around homegrown terrorism a couple days ago in the New York Times. And frankly, if he'd been my undergraduate, the notion of linking all those random things together, right? I don't think we see 8 random cases of Christians being linked together as somehow some kind of homegrown, new Christian threat, right? Even though I think we could similarly find 8 very, serious, terrible cases by Christians in the past 6 months too. And so I absolutely think that there's sort of this new paradigm where it's just like, oh yes, we thought we didn't have homegrown terrorism, but now we do, right? And I think we do have to be raising questions about that and raising questions about, the kind of, very ephemeral, here to here to here to here, and all of a sudden you have this phenomenon that then has been described as a phenomenon. And so I absolutely agree and think that, again, some well-worded letters to the editor about that piece, I think, would also be in order, because I think it was just, academically really, it's shoddy, and we have to expect more than that, and so.
We live with a certain reality in America right now. And, as the beats, the drums of war rage on to the Muslim peoples of Afghanistan, and as, this almost comprehensive effort to suppress the Muslims of America is being played out, it takes people of conscience to stand up and to bear witness to it, And I invite you guys to bear witness to my brother's case. We're going to try to get the transcripts, daily to post them up. Unfortunately, my brother's wasn't the first case, and we've sat through many cases, ridiculous cases, where juries convicted in record time because, the prosecution played on their fears and played on, what the media has fed them about the Muslim people. And we're going to be less safe and less free if that keeps being perpetuated. And the closing of Guantanamo means absolutely nothing if the Guantanamo mindset is very prevalent in America. And if you can ask Shane that the Obama administration is taking the same positions as the previous administration, they're just so much more sophisticated and eloquent. They don't sound like cowboys. They don't have John Yoo and David Addington. Right now, they have other people who sound more eloquent. And what we're having is the same mindset being perpetuated, being propagated. And again, I ask you, as people of conscience, to bear witness to it, and please come to the court if you can, if you have the opportunity. And, talk to people about my brother's case if you have the opportunity. So, thank you.
So there's clearly a sense of urgency around this and a need to open up these proceedings a bit more than they have been. This is one way of doing that, and we need to continue doing that. Just a reminder about some of the resources on the web. there are 3 websites, and there are flyers outside. There's one flyer, you'll see it looks like a comic, and on the back actually has a list of all the websites that I'm going to give you right now. So please grab one of those on your way out. The websites are thawaction.org. Again, that's thawaction, T-H-A-W, action.org. And that's Theaters Against War's website, and that will give you information about these ongoing weekly vigils outside of the Metropolitan Correctional Center. Educatorsforcivilliberties.org, where there is a petition that academics and scholars and intellectuals have been asked to sign, and there's also opportunity on the website to email Attorney General Holder. Is he listening? Of course, is a question, but still we need to do everything we possibly can. And the third website is freefahad.com, and that will give you links to press around the case, transcripts from the court, a short documentary that will give you an overview. It's a good way of also sort of sharing it with other people. And there's opportunity to donate to his legal defense as well on that website. And they will post the most current news in terms of the court dates, when and where. So again, all those websites are listed on the flyers outside. I'd like to thank our panelists once again, Professor Jeanne Theoharis, Shayana Kadidal from the Center for Constitutional Rights, and Faisal Hashmi.